This is the best advanced estate planning trust for married couples. There's two major reasons why you would need this mandatory AC trust. So one reason is tax planning to get some other tax benefits. Another reason, or a different reason, could be to exercise more control over your assets after you pass away. So let's see how this works. Advanced trust, it always pours into a dynasty trust. Revocable, as long as the trustors, the trust creators are alive, they'll transfer their assets in there. And here's how it looks after one person passes away. The alive spouse takes all of their assets or their half of the community property into a trust that is revocable. They still have full control over their half of the assets. Now, the deceased person's assets, all right, so the alive person, they're going to be the beneficiary. They're also going to be the trustee. They're going to be in charge of managing this. And all of these assets are going to get a step up in basis to the fair market value as of the date of death. All right. And then after the surviving spouse passes away, their share of the assets, their half, is subject to the estate tax, but they have their exemption against the estate tax. Currently, that exemption's $10 million adjusted for inflation, a little star. So it's actually 11.7 million in 2021 for those that want to get technical. And then these assets over here will get another step up in basis when the surviving spouse passes away. Now, a lot of the trusts that I do, a majority of the trusts are what we call a continuation trust, where it just has this portion where we send everything to the surviving spouse. So they have full control over everything, and then everything gets another step up in basis when they pass away. And then there's one exemption to use against the estate tax. Okay, so with this advanced trust, this is a little history in estate planning. It used to be very common to do an AB trust. Now, the main idea of this trust was to get a second exemption against the death tax. So this is how we got to use the exemption of the deceased person. A whole other trust had to be created. So this B trust is irrevocable. The dead person's share is irrevocable. So whatever their wishes are, it can be locked in. So besides the tax reasons to do this trust, the other reasons is if you want to have more control over what happens to your assets if you're the first one to pass away. As part of this control, it depends on who you name as the beneficiary. So to really get control, if we're doing this reason, or if we're doing this trust for the non-tax reasons of you don't want your kids to be disinherited by the surviving spouse, or you don't want to support your spouse's new partner, then the trustee really matters. You really need an independent trustee to oversee the trust. If you name the surviving spouse as a trustee, there really is no protection. If someone wants to set up one of these trusts for the non-tax reasons, I do require them to get other trustee. Otherwise, it just doesn't work. I've been on all sides of these things. I've represented all different parties. So it's really easy for a surviving spouse to change this trust. I've done that for a lot of surviving spouses. The beneficiary of this trust is always going to be the surviving spouse. They get a benefit during their lifetime, but you can choose who the remainder beneficiaries are. Now, with this traditional B trust, the assets, they use the exemption on the way in. So all the growth, whatever it grows to, is not subject to the estate tax, but there is carryover basis. If the house was worth $100,000 when it went into the trust, but on the second death, if the house is worth $150,000, the basis remains the first $100,000. So there is no step up in basis. If the kids sold the house for $150,000, they may have a gain to pay for the difference between, or there may be taxes paid on that gain, the difference between basis and the sell price. So old traditional estate planning, we did A, B trust, and then the overflow went into a C trust, also called a Q-tip trust. Not to clean your ears, it's a qualified terminal interest property for those that want to get technical. So, but basically the C trust was an overflow for the B trust. So if it was a $25 million estate, 12.5 would go over here to the surviving spouse, 12.5 over here to the B trust, and then the amount over that exemption would go into the C trust. So the C trust is also irrevocable. The beneficiary of this is going to be the surviving spouse. It has to be, and the surviving spouse has to be able to get all of the income from this trust in order to use this marital deduction. The trustee, again, if you want to control, you can have an independent trustee, or if we just want the tax reasons, the surviving spouse can be the trustee. Now, the assets that come out of the C trust on the second death, they are subject to the estate tax, but they get a step up in basis. So this new concept came around a few years ago. I guess it's been about 5 or 6 years now, but called portability. It means that the surviving spouse can take the exemption of the deceased spouse without a trust. So it means that this B trust is no longer necessary in order to get the second estate tax exemption. When that became a permanent option, the planners, all the tax nerds got together and they said, wait a minute, what's the best way for people now? How can people minimize taxes given these new laws and these new options? So for a lot of people, it's better that their asset or half goes into the C trust because the assets get another step up in basis on the second death. Now with portability, they can use, it's taxable, it's subject to the estate tax, but there's a second exemption that can be used on the second death. So you can get 2 estate tax exemptions. Now this video, we're going to get into dynasty trust, talk about the GST exemption. So portability, you can allocate your exemption against the estate tax, but it is not for GST exemption. So GST exemption, basically there's a limit on how much you can put into these dynasty trusts, these GST trusts. These dynasty trusts are not subject to the estate tax again. So whatever amount goes in here is not subject to the estate tax again. All of our dynasty trusts contain what I call a GST filter clause. And what that is, it's a clause that basically says don't overflow this dynasty trust. Don't put in more than the GST exemption. If the trust has more than the GST exemption, then the excess goes somewhere else. GST exemption is different than the estate tax exemption, although they're currently both the same amount. As long as I've been doing this, they've always been the exact same number, but they could be different numbers, and maybe in the past they were, but just never during my day. Now this B and C trust, they can also allocate GST exemption. So it is possible to get the second exemption against the estate tax through portability without a tax return, but to allocate, to get the second GST exemption, so where you can put more than 10 million, so up to 20 million into these dynasty trusts, we need a way to get that second exemption. That's some of the tax reasons why you would need this more advanced trust to get the second GST exemption.